For most of the bind over, I believe that the facts set up everything that's needed for count one, as it clearly shows that it's a substance controlled substance. It's cocaine. It was tested by the True Narc. In this case, Officer Hussein had testified about finding the narcotic residue inside the vehicle. Then the two larger bags, which were found at the hospital. In this matter, the defendant was the only one in the bathroom at the time in which these narcotics, or prior to these narcotics being discovered. He was informed not to flush the toilet, did so anyway, was also informed not to basically make sure that he could be visualized. In this case, he saw that he bladed himself towards the trash can away from the view. There was fervent movements with his hands, and then all of a sudden there happened to be, while he washed his hands, there's two baggies of one bag of cocaine, one bag of crack. It just happened to be wet at the time in which, generally right after he washes his hands, Your Honor. So it's been tested and shown as far as count one is concerned.
All right, guys, buckle up because this case wastes no time heating up. Right from the start, prosecutors come in swinging with lab-confirmed cocaine, drug residue inside the suspect's car, and a suspect caught red-handed in the hospital bathroom. Despite being warned not to flush the toilet, he does it anyway. Moments later, two soaking wet baggies, one of cocaine, one of crack, are pulled from the trash. And what a coincidence. This happened just after the suspect made suspicious movements and washed his hands. Everything about this moment screams setup or cover-up. No one saw him toss anything, but the timeline is too tight to ignore. The first 70 seconds set the stage for something far more serious than simple possession. Stick with this one, it gets heavier from here.
Testimony is very relevant into the indications of narcotic trafficking in cells. It's our position, Your Honor, based on the fact that there was a scale there, multiple small baggies for numerous small baggies for packaging, tear-offs, which are commonly used as packaging two different types of narcotics placed in two different bags, both of which are above the normal use for personal use. In this matter, we have one at 14, I believe one at 30 grams, Your Honor. One of those, I believe, which would be the cocaine, this pure cocaine, Your Honor, 30 grams, that's over an ounce. He had over an ounce of cocaine and then approximately half an ounce of crack cocaine, Your Honor, with baggies, with the scale. Those are every single thing beyond our address book that one would need for distribution, Your Honor. So we do believe that there is more than enough probable cause to sustain the additional charge that the people have requested.
This is where things explode. Prosecutors drop a bombshell. Not only were there drugs, but there was intent to sell. We're talking 30 grams of cocaine, nearly half an ounce of crack, a scale, multiple baggies, and packaging materials. That's not someone with a habit, that's someone running product. Officer Hussein walks the court through it all, laying out the items like a checklist for drug distribution. 2 different drugs in 2 different bags, both beyond personal use quantities. This wasn't sloppy, it was systematic. It wasn't hidden, it was packaged. The courtroom shifts. This is no longer about being caught with drugs. It's about being caught mid-operation. And the prosecution's tone? Dead serious.
Intent to deliver, which would be a delivery of manufactured and controlled substance less than 50 grams. We showed that the total weight of this was 45 grams, Your Honor, just under that 50-gram threshold, and that it was all cocaine or a mixture that contains cocaine, Your Honor. So for those reasons, and of course, we've already established venue, time, location, and identity. So, Your Honor, at this point, we do ask that the court bind over on the original count 1 and the added count 2 of delivery and manufacturing of a controlled substance less than 50 grams.
Thank you. The first element of this, of course, is that the defendant possessed controlled substance. In this case, the allegations cocaine and crack cocaine. There was a pat down. And a full search before the hospital, before any of these allegations happened, by trained law enforcement officers. They know how to do the searches. Officer Colorasi was in training, but also trained to do a search, obviously. Nothing was found on my client's person. Nothing in his system from the blood draw. No drugs, no alcohol. So really, the possession comes down to these two bags that were found in the trash can in the hospital bathroom. A bathroom that is open to the public 24/7, doesn't require any special entry. Anyone could walk into that hospital and use that bathroom. I was curious how often they cleared the trash can, but the officer from the hospital didn't know. So obviously those bags could have been there for any amount of time. The officer from the
Now the defense swings hard with their counterstrike. Their opening punch? The suspect was clean. Nothing in his system, no drugs on him, no signs of recent use. Officers searched him thoroughly before the hospital trip and found zero contraband. So how did those baggies end up in the trash can? That restroom was open to the public 24/7. No security, no cameras, no access control. The defense builds its wall on reasonable doubt, arguing someone else could have planted those drugs. They even questioned the hospital's trash removal routine. Could those bags have been there for hours or even days? It's not just a defense, it's a reset of the narrative. Suddenly this isn't a slam dunk case. It's a mystery, and the suspect? He might just be in the wrong place at the worst time.
At the end of the day, all he said was, well, he was drying his hands for an irregular amount of time or something to that effect. I mean, that's, I just, I just don't think there's a lot there to support probable cause, respectfully. And no one saw my client put anything in the trash can. And of course, Your Honor knows there's two types of possession, right? Actual and constructive. Presumably the people are arguing both, that he actually possessed these, but, that nothing was found on his person. Constructive possession is, of course, and then there's case law, I think Mr. Danner is aware of. There's a Sixth Circuit case interpreting Michigan law, and then there's a Michigan Supreme Court case, and I have the citations, I'll mention them quickly, but basically proximity to contraband is not sufficient proof for something else connecting a defendant to the contraband, whether it's a weapon or a controlled substance. And I won't go through a lot, but I would just like to, for the record, say that I'm referring to a Sixth Circuit case, Parker v. Renico, 506 F3rd 444, interpreting Michigan law, decided October 17, 2007. And that case cites many cases, including a Michigan Supreme Court case, People v. Wolf, WLFE 440 Mich 508, decided in August 31st, 1992. Very briefly, what the Sixth Circuit says is, as with the federal rule, a person has constructive possession if there's proximity to the contraband, together with indicia of control. In other words, proximity alone never suffices. Cites the Michigan Supreme Court case. And
now the courtroom turns into a legal battleground. The defense brings out the big guns, Parker versus Renico, People versus Wolf, to attack the prosecution's core argument. They say proximity alone doesn't prove possession under Michigan law. Just being near drugs doesn't mean you controlled them. There has to be intent, dominion, or ownership, and none of that's been shown here. No one saw him toss the bags. There's no DNA, no prints, no weapon, no confession. The defense tears into constructive possession like a surgeon with a scalpel. They're not just questioning the evidence, they're dismantling the logic behind the charge. It's a brilliant play. If they can kill the link between suspect and stash, they can crush the case before it even sees a jury.
The people have sustained their burden of showing sufficient evidence that there's probable cause to believe that the defendant committed the offense of possession of a narcotic less than 25 grams. Also, given all of the testimony, in particular that by Officer Hussein, there is enough. This court believes that the defendant should also be bound to overstand trial on the additional charge of possession with intent to deliver a controlled substance less than 50 grams. And so the court would bind the defendant over to circuit court on both those counts. The court would also indicate that the issues that are raised by the defendant with regards to those cases and actual possession, the court does find, for the purposes of probable cause, that those particular prongs under either test are met. To the extent there might be an argument as to what could be inferred or the intent, that this court would believe would become a question of fact that would properly be before the jury. But I think there's enough there to bind the defendant. Well, I know there's enough there to bind the defendant over. Defendant's bound over on count.
Question, according to the Michigan Supreme Court, is whether the evidence establishes a sufficient connection between the defendant and the contraband to support the inference that the defendant exercised dominion and control over the substance. That's beyond the mere proximity. So I respectfully assert that there is not probable cause on that first element for actual or constructive possession. The second element, defendant knew that he possessed a controlled substance. That would have to be inferred. There's no evidence of that. There's no statements or admissions. So that would have to be inferred from the first element. And, well, there is testimony of the weight. So that's the third element. So for all those reasons, well, I'll leave it at that. Thank you.
I really don't.
And finally, the moment of truth. The judge delivers the ruling, and it's a game changer. Despite the defense's sharp legal tactics and multiple case citations, the court rules there is probable cause. The drugs, the packaging, the strange behavior, it's all enough to move forward. The defendant is officially bound over to circuit court on both charges, possession and possession with intent to distribute. The judge acknowledges the defense's concerns, but says those arguments belong at trial, not here. The court sees enough for a jury to decide. The case isn't over, it's just beginning. The next round will be a full-on legal battle. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.